All right, guys, buckle up, because today we're diving into a sovereign citizen showdown that is absolutely wild. This case slipped my mind until now, but trust me, you'll be glad I remembered it. It all starts with a debt collection trial, but what makes it so entertaining isn't the paperwork, it's the way the defendant, Kevin Hurst, tries to twist court rules into his own game. From the very first exchange, you can feel the tension building. The judge is calm, the lawyer is professional, but Kevin, he's about to turn this courtroom into a one-man circus.
We are on the record calling 2-1-170-598. Midland Credit Management versus Kevin Hurst. Date and time for pretrial. Your appearances.
Good morning, Your Honor. May it please the court, Suzanne Strickarts, P44018, on behalf of the plaintiff.
And your name, sir?
Kevin Hurst.
Okay, where are we on this file, people?
Your Honor, we had a pretrial. You opened up a written discovery. We did send discovery out. We did receive it back, apparently unopened, indicating there was a written on the envelope itself. It had written, I'm reading here, I do not accept your offer to contract, all rights reserved, UCC 1-308, signed, and then it was a return to sender, Judge.
All right, Mr.
So we attempted to do discovery anyway. So.
Mr. Hurst, did you refuse to accept the mail?
Did I refuse to accept the mail? Yes.
Sir, you can't do that.
I can refuse to accept any mail that comes to me.
Now here's the setup. The lawyer for the credit company explains that they sent discovery paperwork, the official documents that outline evidence and admissions. But instead of opening it, Kevin returned it with a scribble saying, I do not accept your offer to contract. UCC 1-308. If you're wondering, that's Sovereign Citizen Code for I don't follow your rules. The judge stays him down and asks, did you refuse the mail? Kevin answers yes, proudly. And right there, the judge tells him flat out, you can't do that. Already, the case is sliding off the rails. Clip 2. The judge patiently explains the rules, but Kevin's answers only make things worse. He insists he doesn't understand the debt, doesn't know what's going on, and acts as if ignoring legal mail somehow erases the lawsuit. The judge drops the hammer. Refusing to answer discovery means everything in that packet will automatically be considered true. Imagine walking into trial where all the accusations are already legally proven because you ignored the paperwork. That's the hole Kevin just dug for himself.
This is what we're going to do. One of the things she sent you were requests for admissions. If you do not provide proper answers to those requests for admissions, they are deemed to be conclusively admitted. Do you understand that, sir?
Objection, Your Honor.
Do you understand what I have said?
No, I don't.
All right, here it is. I open written discovery in this matter. You have a right to whatever legal position you want, but you do not have your own set of court rules. Among the things that the court rules provide when written discovery is open is that she can send you requests for admissions. Those requests for admissions are in writing and they must be answered under oath and in a certain time frame. If they are not answered and filed in accord with the court rules, then they are deemed to be conclusively admitted. You will not be able to contest those things. And that was what was sent to you, sir. And that time to start running those started with the day they were mailed to you.
Your Honor.
You don't want to accept
I'm not even sure. I do not have any understanding of this is my debt or.
And just when you think Kevin might calm down, he pushes harder. He argues he doesn't even understand why he's in court. The judge, holding back his frustration, compares Kevin's behavior to making up his own set of rules. This is where the comedy hits. You can practically hear the sarcasm in the judge's tone as he tells Kevin that if he wants to ruin his own case, that's his choice. Meanwhile, the lawyer calmly explains that she attached account statements and proof of the debt in the very packet Kevin refused. Yep, the exact evidence he claims doesn't exist was in the envelope he proudly returned.
They just coming with these allegations. I'm trying to see and verify if it is. When they called me the first time, they should have sent out verified documents stating that the original creditor and who it was and that I truly owe this debt.
Well, Your Honor, just indicate that we did attach to those.
They already,
Excuse me, Mr. Hurst.
Excuse me, I wasn't finished.
Excuse me. She was talking.
I wasn't finished. She
All right,
cut
I'm going
me
to
off.
mute you, Mr. Hurst. I'm not going to have this.
Your Honor, she cut
I'm
me
not
off.
gonna
I was
have
still
this.
talking.
This is not a clown show.
Oh
You will
my
speak
goodness.
one at a time.
I can't finish my
You
statement.
will speak one. Don't interrupt me again, Mr. Hurst.
Go ahead, sir.
Why, thank you. You will speak one at a time. You will not interrupt each other. You will not interrupt me. Do you understand what I have said? Mr.
Yes, sir.
Hurst?
I don't understand anything.
Okay, fine.
I don't even understand why I'm here.
I'm going to mute
I don't
you.
even understand what's going on.
All right, guys. Here's the twist. Kevin starts demanding answers that were already provided in the rejected packet. He wants proof of the debt, a clear chain of ownership, and verification from the original creditor. The lawyer politely explains that all of that was included. Kevin admits he sent it back unopened because he thought it might be a contract. The judge steps in again, almost begging Kevin to accept the packet next time. He warns that refusing again will essentially end the case right then and there. It's like watching someone argue with a lifeboat while their ship is sinking.
I'm muting Mr. Hurst, and I will let Ms. Strickard say what it is she wishes to say. Then I will unmute Mr. Hurst and allow Mr. Hurst to speak. Ms. Strickard, you were responding, Mr. Hurst.
Yes, sure. I was just indicating that we did attach the account statements, the full chain of title and seller data sheet to the packet. So even though there was no requirement, we did want to provide that to the defendant. And so that was in, all of those materials were in the packet that was rejected, Judge.
Well, let's let Mr. Hurst respond.
Okay, so the understanding that I have is that they should have contacted me 5 days after they should have gave me documents 5 days after they contacted me about the alleged debt. I told them I have no recollection of the debt. Yeah, I don't even know enough information to admit or deny the allegations to the debt. So if they're accusing me of this debt, I would like to ask them a few questions so that they can verify that this debt even belongs to me. And that's why I refuse the packet, because I don't know if they're trying to contract with me or not.
The judge even goes out of his way to remind Kevin that he has a constitutional right to represent himself, but he does not have the right to invent his own court rules. He strongly suggests Kevin get a lawyer, clearly doubting he understands what he's doing. But Kevin sticks to his sovereign citizen playbook, asking more questions about why the paperwork wasn't sent differently. The judge keeps repeating the same thing. The rules are the rules, and Kevin's refusal to play along will cost him dearly. It's courtroom patience versus stubborn ignorance, and patience is starting to wear thin.
I didn't know what it was, so I sent it back.
All right, let me explain it to you again. Whatever political views you have,
I had no understanding that they were sending me these things. They didn't even tell me that they was going to send me. In the last court date, did they say, or did she say, we're going to send you something?
sir, I opened written discovery. That allows you to serve written discovery. That allows her to serve written discovery. And she did so. If you elect not to receive it, then that's on you. That's the risk, and you bear the risk of that. But I would urge you, and let me tell you, as I told you at the beginning, you have an absolute constitutional right to represent yourself, but what you do not have is a right to your own set of court rules. You may not be frustrating the court rules, sir, by refusing to accept mail. If that's the choice you make, then that's the choice you make, and you will have to live with the consequences of that. I would urge you, sir, perhaps you might want to get counsel, because I don't think you understand the process, and I'm not at all sure you understand the consequences of the choices that you are making. However, as I indicated, you have an absolute constitutional right to represent yourself. I would urge you to get counsel. So I'm going to give you another date. And sir, she is going to do what she does to represent her client, and you're going to do what you do. And if the court rules cut against you, then so be it.
The hearing continues, and the judge gives Kevin one more chance. The lawyer is told to resend the discovery packet, and the judge practically begs Kevin to open it this time. He warns that failing again will mean the requests are conclusively admitted. In other words, Kevin loses automatically. Even then, Kevin argues about timelines and tries to negotiate how documents should have been sent. You can sense the judge's restraint cracking, but he still gives Kevin another shot. It's rare to see this much patience in court, but even patience has a limit.
I got a question. They are claiming that this debt belonged to me. Would they have to produce all the proof and verify that this debt belongs to me?
The plaintiff has the burden of proof, Mr. Hurst.
That's right. So she had to produce the proof that this debt belongs to me, right?
She has the burden of proof.
Okay. Thank you.
All right.
Judge,
I'm sorry, Ms. Rickards?
Your Honor, would it be possible for us to receive a motion date for, say, mid-July?
Let's give him one more opportunity.
Oh, you want me to resend the packet, Judge?
I want you to resend the package. And sir, let me urge you as strongly as I can. So receive and open the package. Because if you do not, the request for admissions will be deemed to be conclusively admitted. The lawsuit, as a practical matter, will be over. Do you understand what I have said to you?
Yeah, I understand. I got a question. Should they have sent me something before they send me this package since the last court date?
Sir,
to verify that?
Sir, they're not required. If you think you need some information, you have the right to seek discovery too. But you can't tell them how to litigate their case. The same way
so she's going to send me a packet and I'm going to send her back a packet as well, right?
No, you're going to do what you choose to do. She's going to send you again those requests for admissions.
Well, you said that
Don't interrupt me again. We had this conversation before, didn't we?
Sorry.
We had this conversation before.
Go ahead.
As a courtesy to you, she's going to send you the request for admissions one more time. You will either accept the package or you will not. You will answer and serve the request for admissions in accord with the Michigan court rules, or you will not. And then if you do not, then those things will be deemed to be conclusively admitted. If you choose to send written request for discovery, you have a right to do that too. You can send written interrogatories, request for production of documents, and request for admissions. Same as her.
Well, same as her, but not the same, since he doesn't have the 8+ years of law school to help defend his own case. Now that's the end of the first appearance. He finally accepted the packet, so now let's go on to the second appearance.
All right, we are on the record. This is 21-170-598. Midland Credit Management versus Kevin Hurst. Date and time for pretrial. Your appearance.
Good morning, Your Honor. May it please the court, Suzanne Strickhartz, P44018, on behalf of the plaintiff.
And what is your name, sir?
Kevin Hurst.
Okay. All right.
I do hereby reserve all of my rights, waiving none, not to be compelled to perform under any contract or commercial agreement that I did not enter, knowingly, voluntarily, or intentionally. I do not accept the liability of any compelled benefit or unrevealed contract or commercial agreement without prejudice.
Now here's where it gets hilarious. At the next appearance, Kevin walks in with a speech straight out of the Sovereign Citizen playbook. He declares, "I reserve all of my rights. I do not accept liability. I do not consent to any contract." It's a flood of legal-sounding nonsense that means absolutely nothing. The judge listens, unimpressed, before asking if he has anything useful to say. Kevin, of course, says no. The lawyer then calmly states that discovery is complete and motions are ready, while Kevin looks like he just spoke magic words that should have ended the case. Spoiler alert, they didn't.
Is there anything else you want to say, Mr. Hurst?
That's it.
All right. All right, where are we on this file?
Judge, discovery's been completed. Motion for summary has been filed. We are looking for the court to assign a date.
Okay. Let's get you guys a date. Mr. Hurst, do you have the motion for summary disposition filed on behalf of the plaintiff?
It looks like this.
What's that?
It looks like this.
I'm asking
Yeah.
if you received the motion for summary disposition filed by the plaintiff.
Do I have it?
Yes, sir.
Yes.
Okay. So let's set you a date for hearing and we'll move on. Does July 26, July 26th at 10 o'clock. Does that work for everybody?
Yep.
Yes, Your Honor.
Okay. July
Thank
26th at 10 o'clock, we will hear the plaintiff's motions for summary disposition. Sir, if you wish to file and serve an answer to that motion for summary disposition, you must do so within the terms provided in the Michigan Court Rules. We'll hear the motion July 26th at 10 o'clock. Again, sir, if you want to file an answer, be sure to serve both the court and the counsel for the other side.
And that's where we leave things. Kevin tried to dodge his debt with scribbles, speeches, and sovereign citizen slogans, but the court never bought it for a second. The judge gave him chance after chance, patiently explaining the process. But in the end, Kevin's tactics only made him look foolish. All right, guys, if there's one lesson, hey, it's this. Court doesn't run on imaginary rules. You can't just write "I don't accept" on an envelope and expect to win. Sovereign citizens may think they've cracked the code, but in reality, they're just giving judges free comedy in open court.